morning, everyone. I'd like to welcome you all here today for the first in our three-part webinar series on the Aarhus Convention. Many of you will be aware that CLM launched our Centre for Environmental Justice in February this year, the objective of bridging the gap between environmental and social justice issues. And this includes bringing an environmental lens to many of the issues that the organisations attending here today work on. For example, substandard housing conditions, energy poverty, poor mental and physical health, and inadequate access to services such as transport or amenities such as green space. Ensuring that everyone has awareness of their environmental rights is a critically important aspect of this, and we especially welcome those joining today who are completely new to the area. We hope that the information provided on the Aarhus Convention might provide new insights in thinking about how social justice issues can be addressed holistically. And over the course of the three webinars, we will be answering questions such as, why is access to environmental information a critically important right? What does public participation in environmental decision-making actually mean? When is it necessary to bring legal cases to protect environmental rights, and who gets to go to court? I am very grateful to the Community Foundation for Ireland for funding this training, and to Nicole Lange and Fred Logue, our speakers here this morning. There will be a very short space for questions and answers at the end, so please use the Q&A box to ask any questions you might have. If you see a question similar to one you might like to ask, simply upvote the question with the thumbs up function, and that will make the question more likely to be addressed. As this is a short event, I don't want to use up any more time, and so I'd like to introduce our first speaker, Nicole Lange. Nicole is an environmental and administrative lawyer who is specialised in environmental protection and nature conservation, working with DLA Piper in their Amsterdam office. Thank you, Nicole.
Thank you, Rose. Yeah, good morning to you all. I'm very surprised and glad that there's so many participants, I've been told today, that are joining in for our sessions on the Aarhus Convention. And just to get comfortable, I wanted to start off with a poll so I can get to know a little more about you. Now I'm kind of hoping that, oh, great. Yeah, so the first question of my poll, how are you all today? I've divided the answers in great, thanks, I'm all right, could be better, and it's one of those days. And I'm sure we've all had one of those days. I can say that today I feel like great, thanks, but oh, fantastic. Okay, I'm glad to see that you are all great as well. And all right, I mean, yeah, that's good. And then secondly, I wanted to ask, so I've only been to Dublin twice, but the times that I've been there, it was fantastic. And I just wanted to ask if, do you guys agree with me that Dublin is one of the nicest and coziest cities in the world? Oh, people are disagreeing with me. Might those be the people from Cork or from Limerick then, perhaps? Okay. Ooh, that's about 50-50. Okay, well, then you might need some convincing at that point. So diving into the material a bit more, question 3, have you ever heard of the Aarhus Convention before today, before this training, before you saw it popping up on the Community Law and Mediation website? Okay, so fairly a lot of you have heard of it before, which is good, and that makes it more fun for me and challenging to bring something new to the table as well. And then the fourth question, and I'm very interested in this answer. Who do you think the Aarhus Convention is primarily meant for? Do you think it's meant for me, for lawyers and big companies, for governments and governmental bodies, or for citizens and civil society? Wow, you're pretty much taking away from me what I was about to tell you all, which is fantastic. So yeah, I'll come back to it in a second, but you're right, it's actually mostly meant for citizens and civil society, although it's been used by governments and governmental bodies as well. And then finally, do you think the Aarhus Convention might be useful for yourselves? Oh, that's great. We're unanimous. Well, that makes my job today a lot easier because I was about to convince you why it's useful, but I already have you on my side. And then let's move to the theory behind it all. Hold on, do I need to stop the poll? Yes. Yeah, there we go. So the Aarhus Convention, what is it really and why was it adopted? So Aarhus, as you might or might not know, is a Danish city. And here a lot of smart and idealist people came together. And they started to establish a convention. And they did this under the roof of the United Nations Economic Commission for Europe. And they managed to get together 47 parties, including the UK, the Netherlands, and Ireland. And the Aarhus Convention was founded on the 3 fundamental rights following from Principle 10 of the Rio Declaration. And for those of you who don't know, the Rio Declaration is a declaration on the environment and development, and it defines sustainable development in 27 principles. And it aims to use these principles as a guideline on the road to achieving a more sustainable world. So these 3 rights, the access to information, the access to public participation, and the access to justice. I've always been told never to put something on a slide unless it serves a purpose. So this picture serves a purpose. The diagram shows how these 3 principles work together. So they're not to be used individually all of the time, but they have a much stronger impact when they're viewed in relation to each other. They were aimed to create, the Aarhus Convention was created to empower the role of citizens and civil society. And it was believed, and having dealt with the Aarhus Convention in my daily practice, I actually believe this as well, that the 3 pillars allow for greater environmental rights and promote a greater governance. So looking at the 3 pillars, I think the pictures kind of speak for themselves, but the first is the access to environmental information. And the rationale behind this is that states hold a wide variety of information on the environment, which is often used to develop policies or measures to protect and report on public and environmental health, or information on how the environment is or could be affected by certain decisions made by government and other public authorities. This pillar requires the states to the convention to make sure the public has access to information on all such areas. The second pillar is the public participation, on which my fellow DLA colleague Tessa will be presenting next week. Governments and public authorities are often required to make decisions on matters that can have ramifications for the environment. And this pillar requires that the states facilitate public participation in that decision-making process, whenever such decisions can in any way affect the environment. This is often implemented through forums for the public to comment on certain developments or projects or proposals or planning. I like to summarize it as give all the people involved in a certain project or involved or influenced by the decision a say in the decision making. Let them be part of the process because this will serve a better outcome. And finally, the access to justice. States will have all sorts of different laws and policies to ensure protection of the environment. And this pillar requires that states have administrative or judicial procedures in place for the public to be able to challenge those decisions or acts that perhaps breach the state's environmental law or legislation. It also ensures that access to court should be fair, equitable, timely, and not extremely expensive. So if an environmental decision is made, you should be able to initiate proceedings to challenge it. So then how is it implemented in Ireland? And as I said, I am not from Ireland, and I've tried my best to wrap this up and explain it to you as best as I can. But it's a bit of a boring topic because it comes down to boring legislation. which is a patchwork of about 60 pieces of legislation that ensure that these three pillars are woven into the Irish legislation. For instance, the one we're talking about today is the access to information on the environment regulations. But with regard to public participation, it is rather scattered over the different Irish planning laws or legislation regarding licensing or permits. And with regard to justice, there are some acts in place that ensure certain procedural costs apply when it concerns environmental cases, and it requires judges to recognize the application of the convention whenever it's relevant, meaning that if you seek justice, you are not ought to prove why the Airways Convention would apply. That is up to the judges. They should see, because in this case, it's an environmental matter, so we should be applying the Airways Convention. Then, the first pillar. So how do you get the information you want? Well, in order to understand what kind of information you can retrieve, you should understand what kind of information, of environmental information, is meant under the convention. So what are we talking about? It's quite a broad understanding. It can be the information on the state of things, policies or measures taken, on the state of human health and safety. And it can be either written, visual, oral, electronic, or via any other material, as long as it regards the environment. One thing that always reminds me of is in the Netherlands, we had a case where someone wanted access to a WhatsApp message. And then somebody went to court and said, no, it's a WhatsApp message. It's not something you can demand access to. But because the WhatsApp message actually contains certain information regarding the environment, it had to be made public. So it can actually be anything. So just put this to a test. On this slide, I have set up 6 different kinds of information. And if you could just in the chat box say which 1, 2, 3, 4, 5, or even 6 of these types of information you would say fall within the scope of environmental information. So if you think it's water quality, just type 1. If you think it's 1 up to 6, just type in 1, 2, 3, 4, 5, 6. I'll just pop open the chat box. Great, quick response as well. Well, again, okay, so I see someone leaving out number 4. That's interesting, probably 4. Oh. Okay. Spoiler, yes, all of them can actually be environmental information, but I think it's very sharp that some of you had their doubts with 4, because so did I when I was diving into the topic a bit further. I think 1 speaks for itself. We're talking water quality, which can be more environmental than the quality of the water or the earth or the air around you. But noise nuisances as well. So if there is a festival near you, the noise made by that festival can actually, or the information regarding that noise or how the noise is made, can be regarded as environmental information. Planning policies and activities, a new building on your block, the information regarding the construction of the building would be considered environmental information as well. But even reports on the legislation concerning environmental issues, or even the reports made on that, on the cost benefits of it, can in some cases be regarded as environmental information. And number 5 is an interesting one, which I will come back to a bit later, car production. This is something that in our daily practice we see a lot, because when producing, for instance, a BMW or Volkswagen, a lot of information during that production process is considered secret, and you don't want it out and about. But if you have applied for a permit, let's say for the production of 1,000 cars, and the cars will look like this and that, that information is then at a public authority. And in fact, would become available for a request to make it available on the basis of the Aarhus Convention, because the types of cars and the emissions they will have are considered environmental information. That sometimes crashes with the companies who want to keep their information secret, because it will harm them if their competitors find out what type of car they are looking to produce in the next year. And food contamination, I think, also speaks for itself. If certain pesticides are used on your food, on your crops, you want to know about it. Then, let's see, I can go to the next slide. Yeah. So how then do you go about retrieving this kind of information? To understand the impact of the Aarhus Convention, we have to look a bit more closely on the underlying Access to Information Act and how this works in Ireland. In Ireland, if you request certain information, you should be able to obtain it within a month, and you do not need to state a reason why you would like the information. But there are some limited costs attached to it. Even though, let me go back, even though there is no cost to actually make the request under the regulations, they may charge you a search and retrieval fee for the time they spent in it. Roughly, I think it's 20 euros an hour. And the fee may be waived if it remains under 100 euros. So therefore, I would always advise, if you're going to request information, specify as much as you can, because we all know that governmental workers sometimes like to take their time for stuff, and you don't want to pay a lot of money to have some information made public to you. In the Netherlands, however, documents with environmental information must be provided to the public for free, so they cannot charge you for all the time they spend. And in practice, this resulted into people overloading the governments, even more so because the government in the Netherlands is fined if you don't give the information on time. And the money from that fine goes straight into the pocket of the applicant, meaning that if you request the most ridiculous thing, and this is an actual story, one person at one point requested information on the exact amount of toilet paper rolls in all the public buildings in the Netherlands, the system was frustrated so much that they just had kept fining, and the person who requested the information retrieved all the fines. Well, they obviously went to court because this is such a frustration of justice, and that part of the legislation was scrapped. But they still only have 2 weeks to provide the information. Then we now know what kind of information falls within the scope of the Aarhus Convention, and we also know how to go about it and retrieving it. But are there any grounds to deny this information? Under the Access to Information Acts in general, there's always a bit of a balancing act made by the authority, because in case of, for instance, commercial or industrial confidentiality or personal information, it might not always be desirable to make the information public. But the Aarhus Convention states that if it concerns environmental information, a decent motivation has to be given for why the information can be denied. And there is one exception to this. If it concerns information on emissions, and it really concerns like the exact information of emissions, you cannot outbalance it with another interest, because according to the Aarhus Convention, it's so important that this information be made public that there were no grounds to deny. I have also 2 case law examples to kind of also get a bit of a feeling how these denial grounds work. The first is an example of how a disclosure of environmental information sometimes undermines the purpose of investigation. In this case, it was the client Earth, an NGO, who claimed that the European Commission breached the convention because they withheld environmental information on the use of biofuels by member states. And the Commission said that disclosing these types of information would hinder the investigations made by the Commission on the states looking into their legislation with regard to the biofuels. obviously, the client Earth NGO raised the point that for them, this was environmental information. It was very important that it be made public. But the court ruled that in this case, the Commission could withhold the documents because if these documents on the investigation of the use of biofuels would be made public, it would undermine the investigation. But the investigation aimed to serve the environmental purpose, to contribute to developing legislation to protect the environment. So by making this kind of information public, the goal of the Aarhus Convention would also be undermined a bit. And therefore, successfully, the Commission could withhold the documents on these types of information. And then secondly, a Dutch case from a Dutch NGO, you might know Greenpeace. And in this case, Greenpeace was seeking records concerning the authorization by the Commission on certain substances used on pesticides. And they said that the information on pesticides also concerned information on emissions. So therefore, it should be made public. However, the Commission then argued that just like the example I mentioned with the cars, it was a commercial interest to protect these types of information. But this didn't hold up because the court confirmed that withholding the documents here, because they related to emissions, this was such an overriding interest and disclosure could not exist. So the documents were made available. So these were some examples. I hope maybe to make it a bit more tangible. And that brought me to one of my final slides, just wrapping it up all together. So what does the Aarhus Convention mean to all of us, to all of individuals and all of you? Well, it aims to provide the access of information because it will enable members of the public to know and to understand what is happening in the environment around them. And this will assist them in the public participation in the environmental decision-making. Because in order to participate in a process or even go to court, you should understand what is happening. And for you to be able to understand, you need to read, you need to understand the information, you need access to it. And by providing people with as much environmental information as possible, whether this is proactively, and I think Fred will be touching upon this in a bit, or through requests, local authorities have the opportunity to engage people more fully in the decision-making process, and this enables for better decisions to be made. Ultimately, the access to information will help members of the public to assert their right to live in an environment that is adequate for their health and well-being and results into a better environment for all. And I think that might be one of the reasons why I like the Aarhus Convention so much, because it really forms a bridge between the legal and the environmental and the things that states do and the individual and what you are able to do as an individual. And then finally, I want to leave you with the picture on the left side. As you can see, this is Dutch. So if you're looking back at this PowerPoint on a later point and you want to learn some words, well, there they are. And that was about it for me. Yeah.
Thank you very much, Nicole. And thanks for providing such a comprehensive overview of, I suppose, what the Aarhus Convention means, where it comes from, what its objectives are, but also, and really importantly, the practical kind of everyday issues it can be helpful for and how you can go about getting information under the Aarhus Convention. What I would like is just to remind everybody to have, if they have any questions on Nicole's presentation or indeed on Fred's after this, to maybe pop a question into the Q&A box, and then we can have some time at the end to deal with them. So I'd like to now introduce our next speaker, Fred Logue. Fred is a solicitor specialising in information and environmental law based in FP Logue Solicitors in Dublin. Thank you very much, Fred.
Okay, I was on mute there for a second. So thanks very much, Rose, for the introduction, and also to Nicole for a very comprehensive whistle-stop tour of the AIE directive. I will just kind of maybe talk a little bit about more practical examples of access to environmental information. Personally, in my practice, I would be making maybe over 100 requests per year. It's a very effective tool for people who are using the planning system or worried about environmental issues, and also for lawyers who are trying to represent people in environmental issues. I would have about 20 or 30 administrative complaints to the Commissioner for Environmental Information, and about 4 or 5 high court cases. And I've also acted in a couple of ECJ cases and a few complaints to the Aarhus Convention Compliance Committee on access to information, environmental information. So I'm just figuring out how to move the slide next. Like, I think just to set the frame of it, like, you know, we need an environment. I just took that picture a few years ago outside my house, and you know, the reason we have access to environmental information, the Aarhus Convention, public participation, access to justice, is so that individuals can play their role in protecting the environment. And we actually need the environment. If we don't have it, the world won't be a great place, and we probably won't be there to see it. The second thing I wanted to say is that access to environmental information isn't rocket science. So like, this is rocket science, but the directive itself is actually a very simple, and it's meant to be a very effective tool for accessing environmental information with very little formality, really. And it's built on kind of 3 sections. So access to information on request, which Nicole discussed in quite good detail with lots of examples. There's a second aspect to it, which is probably less well understood, is that public authorities have a legal requirement to organize and keep up to date and to disseminate environmental information, and to use electronic means to do so. So what that means is, not only do they have to give you information on request, they also have to actually have information that's relevant to their function, and they have to maintain it, organize it, and keep it up to date. And then they have to actively publish it. So for example, for planning permission, a planning file fulfills that function. Or if there is, there might be examples of, for the roads, the Transport Infrastructure Ireland publishes data about how many cars are traveling on roads, things like that. And then there's a third, even less well understood obligation, which is to make information available immediately where there's an imminent threat to human health or the environment. So you might have seen in the papers at the weekend that Irish Water discovered that 2 water processing plants had actually been pumping out contaminated water for a day or 2, but they didn't tell anybody for 10 days, and people in these areas were getting sick and they didn't know why. So that's why we have something like that. And I don't think people realize that, you know, not only is it common sense to actually tell people about that, but there's actually a legal obligation as well. So I just wanted to cite this case, which is kind of one of the seminal cases on access to environmental information, where the High Court in Ireland said that that this right of access to environmental information is a fundamental right. So like, it's quite a high, there's quite a high degree of importance that's given to access to environmental information. And then within the Aarhus pillars, it's kind of fundamental, because you can't exercise your other rights without actually having access to the information that lets you do that. It's probably more for kind of the legal people, but the AIE is an EU law, and so it has to be interpreted in light of its objective, which is to contribute to greater awareness, free exchange of views, more effective participation, decision making, and then to a better environment. So it gives you this broad but not unlimited right. The exceptions are limited but have to be interpreted restrictively. Even where there is an exception, there still has to be kind of a public interest balance. So the exceptions are meant to protect public interest or private interests. But even when one of those is invoked, the decision maker still has to decide whether actually the public interest outweighs the interest in the exception. Even if there's stuff that can't be released, they have to give you partial release, so they separate out unexempt information. And then the request has to be considered individually. So you can't be refused on a kind of blanket basis or on a kind of general basis. They have to say, well, this particular piece of information can't be given out, and not that this category of information can't be given out. And then, as Nicole mentioned, there is an overriding public interest in access to information on emissions into the environment. I'll probably say something about that a little bit later. And then if you're refused, what can you expect from a public authority? So the decision has to actually give reasons why you're refusing, and it has to reflect the that the review was conducted in accordance with the letter and spirit of the directive. So any refusal that just says you can't have it, or we've decided you can't have it, or we've decided that it's exempt, it doesn't meet that standard. They have to explain actually and specifically why you're not getting it. And if you disagree with that, you can have an internal review, you can appeal to the Information Commissioner, and ultimately to the courts. There's a few other unusual features. If a lot of people are more familiar with the FOI Act, but for the AIE, as I mentioned, there's an emissions override. So there's very limited exceptions if the information relates to emissions into the environment. And the case law for that has said that it's about the nature and extent of actual or foreseeable emissions under normal conditions. And that so you can check that the emissions are accurately assessed, and you can gain awareness of the effect of the emissions. And the idea of that is emissions into the environment are particularly harmful. And actually they've already occurred. So it's stuff that you should know about. There's particular administrative and judicial remedies. And for the judicial remedies, there's rules that mean that the litigation can't be prohibitively expensive, which means in Ireland that if you win the case, the other party has to pay your costs, but if you lose, you don't have to pay their costs. So it's particularly advantageous for litigants. And then there's a facility to make a complaint to the Aarhus Convention Compliance Committee if it turns out, if you think that Ireland or another party to the convention hasn't correctly complied with its obligations under the directive. And the main one for Ireland to date has been one I took to dealing with delay in the administrative decision making, and that was upheld. So just a very, very quick example. So this is an island in Cork Harbour, which used to be a steel plant. And the bit on the right-hand side where you can see kind of a sandy area, that's where they dumped all of the contaminated waste into the sea over a long period of time. And it was described as Europe's worst contaminated site. And following intervention from the European Commission, Ireland was forced to start cleaning it up and remediate it. So a lot of the information wasn't published or was kind of secret. So my client put in an AIE to Cork County Council, which is responsible for it, and got this this analysis, this risk assessment. And it turns out that the risk assessment discovered elevated lead concentrations in water samples that was draining into the sea. And obviously lead is quite a toxic material, and nobody knew about this. And there was other issues with arsenic, asbestos, PCBs, which are toxic chemicals, which were in the dust and could be ingested if people were near the area. And there was hydrocarbons also leaching into the groundwater and into the harbour. So that's a good example of how AIE can be used to discover something of critical importance, because the council wouldn't give it up voluntarily, so they gave it up when they were forced to give it up. There's another one where there's a derelict site and nothing was been done for years and years and years. So they put in an AIE to find out what's going on. And it appeared that if writing memos could repair derelict sites, this would have been repaired a long time ago. So there was lots of memos. Every time somebody complained, there'd be another flurry of memos. And all of this was exposed then through an AIE request, which ultimately led them to do something anyway to get it painted. And it's still derelict, but slightly better than it was. The kind of final point then is that, environmental responsibilities usually or very often come with a responsibility to create information. So for example, with strategic environmental assessment, there's supposed to be a monitoring program. So the monitoring for unexpected environmental effects. There's legislation that requires registers, so planning registers, there's a derelict sites register, vacant sites, all sorts of environmental information is held on registers. And there's EU law, say for clean air, there's a law that there has to be comprehensive documentation that includes evidence to show that they're correctly monitoring air quality. So all of that means that you can prove that the information exists, even if it's not in the public domain. So if you can prove it exists, you can ask for it. And then just as a kind of nice example, a letter to a local authority, give us your SEA monitoring results. Actually, we don't have any. Okay, we're going to sue you because you haven't fulfilled your legal obligation. Oh dear, you've just caught us red-handed. We'll sort that out. So another very effective use of AIE. And there's I have a rule of thumb that even if you don't get anything, that is it, information in itself. So absence of information is information. So here they had a legal obligation to create some information. They didn't do it. They can be sued over that. The threat of litigation will make them actually comply with that requirement. So I just leave you with an invitation to go and make a ruckus and go off and file some AIEs. It's the best way to actually figure out how to use the system. And thanks very much for your attendance, and happy to answer any questions that come up.
Thank you so much, Fred. That was great. And I have a few questions myself, actually, and I see there's quite a few in the Q&A box. And I just encourage everyone listening, if they have other questions, to please pop them in there too. I just have a question, Fred, following up on some of the things that you mentioned. Like in our work in CLM, we use freedom of information legislation all the time in terms of accessing information. And I'm just wondering, what are the benefits with going through the AIE route rather than the freedom of information route?
Well, the benefit is that, firstly, there's far fewer exceptions, and the threshold to invoke them is far higher. And there's no, in FOI, there are mandatory exemptions, and there's exemptions where there's no public interest balancing test. Whereas in FOI, in AIE, there's no mandatory exception, and all of the exceptions have to have a public interest balancing test. So that's the first one. So there's far less scope to refuse access to environmental information. The second one then is that it's an EU law right. So under FOI, they don't apply EU law, they apply national law. So it's much easier to refuse. And then if you have a dispute, while the Information Commissioner, Commissioner for Environmental Information are more or less the same, if you want to bring an appeal, a court appeal, you have a much more favourable cost regime for AIE compared to FOI, and also the possibility of reference to the ECJ and things like that. So I would advise never to file a request for environmental information with FOI.
Okay, thank you. And then the point you raised about the water plants at the weekend and various other environmental disasters that we have experienced, I suppose, and the obligation to make information about an imminent threat to the environment publicly available immediately. And when that doesn't happen, and it hasn't happened immediately in the past, as you pointed out, what are the remedies available to the ordinary citizen? Is it a matter of going to court and suing the public body, or is there a kind of a simpler way of doing it?
Well, like the thing is, what's the remedy? It's too late if it's already happened. So I think what needs to be, like, I can guarantee you that no public authority has any policy on imminent threat. They don't even know they have the obligation. So what needs to be done is somebody needs to go and force them to actually plan for it. And that may require an House Convention complaint.
Okay, thank you. I'm just going to move on to the
even on active.
So just to move on to the questions coming from the audience. The first question here for you, Fred, is there a case to be made for Ireland to have a special environmental court rather than having cases dealt with in the general courts or general justice court system? It's broader, obviously, than AIE, but have you got any views on that?
I don't have any strong view on it. Like it depends what you mean by environmental court. That there's a lot to unpack in there. What I do think is we should have consistent court decisions, and I'm not sure what that environmental court, but it means that we should have experienced judges who are making consistent decisions. And if that's what, to reinvent anything new to get to that.
And moving on to the next question, which is a kind of a very specific question to a very specific set of circumstances. So I might limit the answer to what we're talking about here today, but one of the attendees has raised a situation where Meath County Council has given away a piece of land to 2 private sporting organisations. What access can be maintained for ordinary people? They acquired this land in the first place through compulsory purchase. Now, rather than getting into advising on the particular case, is there any way that AIE or the Aarhus Convention could be helpful in a situation like that?
Yeah, well, there's a legal obligation, like a local authority has to fulfill certain conditions before it can dispose of land. So there should be a paper trail, and that can be accessed via the AIE or even FOI. So like the way you look at these is you have to look at what the legal obligation is, and the expectation is that a public authority will have documentation to show that it has complied with the legal obligation. So for example, a local authority isn't at large to dispose of land. There's only certain particular reasons why it can dispose of land. So that should be documented, and there usually is a vote maybe on it. So all of that stuff should be written down and accessible. And then obviously disposal of land involves a contract. So the contract has to be in writing. So anyone who's done basic law, there has to be a written contract or a memorandum, anyway, at least for a sale of land, and that should be accessible as well in principle.
Thanks. So moving on to the next question. In your experience, how well do the relevant organisations in Ireland understand their obligations under AIE? And I would just expand upon that maybe to comment, what organisations does it apply to? Are there listed organisations, or does it apply to everybody? And also, again, your experience, is it worth appealing a request for information if it's initially refused?
Well, obviously, like everything in life, there's a mixed bag. Some organisations are very good, some are average, and some are terrible. And I think like across the board, it could always be improved. What organisations? So a public authority is quite a broad definition. And there's 3 levels of public authority. One is, government or public administration. Then you have bodies that are performing public administrative functions. So that I always think that things like quangos, but they also can be private entities. So for example, we have cases now where wind farm operators are public authorities. Private toll motorway operators are public authorities. But also things like the EPA, the IDA, all the local authorities, and Bord Pleanála, there's a wide range, semi-state bodies like Cuilche, Bord na Móna, the ESB, Irish Rail, transport companies, all of these are public authorities. And then there's kind of an outsource. So even if you're not a public administrative function, if the public body is outsourced to you, then you're a public authority as well. So it's quite broad. Was there a third part of the question?
Just, is it worth appealing a decision?
Oh yeah, always. If you really want it, you should appeal.
And then I think the next question is for both Nicole and Fred. So while the Aarhus Convention is great, does it go far enough? What are your thoughts on there being a positive duty to publish all information that has an environmental impact? As it appears, applicants are having to engage in fishing expeditions to see if some relevant data exists. So Nicole, perhaps if you have any thoughts on this?
Yeah, good question. It depends on the perspective. If you look at it from a perspective of someone who's, for instance, applying for a permit, or is still in a phase where they really benefit from it not being made public yet, having a duty to publish everything actively might harm, for instance, some businesses. And a second thing that I think might even be more important, if it is a positive duty to publish all information, the weighing in, the balancing moment that the authorities now make is never made. And like we saw in the case law, I think it was the Client Earth one, in some cases it is actually beneficial for an environmental cause to not disclose. So having a set rule of disclosing everything actively might also lead to some unwanted information being out there and being, or maybe being out there too early or in a different, and then maybe later would be better. So I think it is a great convention. I think there's a lot in it that we can still use, and we should, as Fred said, please go make a fuss. Like, try and use this convention as much as you can, because there's a lot that can be done with it if you know how to use it. But I think the safeguards being built in of balancing it still are valuable in a way. Yeah.
Thanks, Nicole. And Fred, any thoughts?
Yeah, like some very early decisions from the ECJ basically said that all information should be published by default, and that AIEs are really just for matters of detail. You know, and we're not there yet on that. Again, I go back. I've done surveys. I can guarantee you, there's virtually no public authority in Ireland that has a policy on active dissemination. But like what that means is they haven't thought about it. So they are actively disseminating some information. They probably, but they haven't actually decided what they're going to publish or how they're going to publish it. And what usually, or they should be doing, is they should be looking at their AIEs to see what's been requested frequently. And then they should be saying, well, actually, this is requested so frequently and it's been granted so often, we should just go ahead and publish it. And that there should be a kind of cycle of review. And again, that's another thing that might have to be brought to the compliance committee to try and force public authorities to think about proactively how they're going to approach that obligation.
And I think that ties in nicely and perhaps overlaps a bit with another comment here. Can an authority be, inverted commas, encouraged to produce information they ought to hold in any other way, rather than a member of the public having to take legal action, which mightn't be possible because of the costs involved?
Well, public authorities are supposed to obey the law. Like, I'm not sure what more encouragement they need. That's what they're supposed to do. And the judicial review is there for those rare occasions when they don't. But you'd expect that 99 times out of 100, there shouldn't be any encouragement needed, apart from the fact that that's what they're supposed to do.
Yeah, and I suppose just to say as well, it mightn't necessarily involve a trip to the courts. Sometimes a letter which sets out what the legal obligations are can be quite strong in and of its own right. So just to make that point. We've another question here. Can AIE, we're slightly threading into the next webinar next week, but I think it's important to ask here, can AIE be used to access information relating to public participation itself? So that is to ascertain if public participation itself is being undermined.
Well, yeah, but I'm not sure what the question is getting at.
I'm not entirely sure either, but I suppose maybe in terms of processes around public participation in relation to the second pillar of the convention, what processes, for example, a local authority might have in place. Yeah,
no, all of that should be accessible.
Okay. Okay, before we wrap up, I just want to ask the panelists themselves whether they have any questions or final comments that they would like to make. I take the silence as a no. And just to close the event, I'd like to remind everybody here today that today's webinar is only the first in a series of 3, with the next webinar on public participation taking place next Wednesday, September 29th, at the same time, 9:30 to 10:30, and a third webinar on access to justice taking place the following Wednesday, October 6th, also from 9:30 to 10:30, and they're from the same Zoom link that would have been circulated. And in order to understand the full potential of the Aarhus Convention and how environmental rights can be exercised by individuals and organizations, we would strongly recommend that people attend all 3 sessions. Today's session obviously only covered the first pillar, and also to share the information about the webinars with your own networks. So hopefully see you all here next week, and thank you all for attending, and thanks obviously too to our speakers and to Community Foundation for Ireland. Have a lovely day.
Thank you.
Thanks very much.
Bye.